Is it your experience that ADR actually can save litigation costs, and under what circumstances is that so? Maybe we'll start in reverse order and go back this way.
I have found that ADR works in our relationships with our vendors and our customers. We try to build it into all of our contracts with our vendors and our customers to have a stepped dispute resolution process. And I've actually had some success with very informal mediation. We require, if I'm lucky enough to get it negotiated in the contract, we require a provision that before any litigation can be started, you do an informal mediation within a certain time frame that gets negotiated with every contract, and that business people who are not involved in the negotiation of the original contract or in the implementation have to get together and discuss.
That's what you mean by the step process?
A step process before it can go into litigation or any other kind of ADR. We require this, we try to enforce this kind of informal mediation among business people who are not emotionally involved in the dispute. And sometimes the theory of cooler heads prevailing actually does work.
As we handle third-party liability claims, we unfortunately don't have the ability to force people into mediation and arbitration, but we have found in those cases that we're unable to settle informally that mediation is our best tool. Usually the cases that go to mediation are the ones where there is a difference in the value of the case. And in those cases, the mediation helps to, we try to narrow down what kind of purpose the mediation can serve, whether it's getting an independent opinion from a respected judge or mediator in the area to educate the other side. Maybe it's the plaintiff attorney, maybe it's educating their plaintiffs, maybe their case has been oversold, maybe it's been undersold. We don't know all those components, but it gives us an opportunity to start addressing those issues. And many times we find that it diffuses an emotional component. A lot of these people, all they see are our attorneys. All they think of is this big billion-dollar corporation that is just a cold, hard, cash-making machine. They never see that it's people running this company, and they think that we don't care about them personally. So we always try to send a company representative to the mediation. It gives us an opportunity to look at them, view them. Sometimes it's our first putting a face on who our opponent is, where we can size them up as a witness. And it gives them a chance to take a look at us. And sometimes they need to hear an apology. And sometimes they just need to have their day in court, their chance to say, here's how you ruined my life. And they need somebody to listen to that, other than just attorneys who are great at doing their jobs. So for that emotional aspect, which is a hard thing to put, in our business, we have to put a number on what your case is worth. And to these people, there's certain aspects of their loss that are priceless. But it all drills down at the end of the day, if it's going to settle, is just putting a cold, hard number on it. Sometimes if we can address the emotional component that goes into it, we find that once they've had their piece and they've said it and they've heard an apology from somebody, that then they can get down and they can go back to listening to what their attorney has to say and getting down to really settling the case.
Just a quickie on that. I saw Ken Feinberg, who is the administrator for the 911 fund, and he was talking about the experience with that fund, and he said, if what you were talking about is just efficient claims administration, it might have been a lot easier for the government to just say, everybody gets $1 million, here you go. We're not going to have to figure out the appropriateness of the fund, the sum for any individual thing. But he said the real value of that claims administration was letting people vent, letting people say, this is what happened to me, this is the story of my family. They just wanted to have an opportunity to have their day in court, as it were. And I think you've hit on that point. Go ahead.
Thank you.
Yeah, Kim, I completely agree with what you just said. I just would like to add one point, because we talk a lot about severity cases, but there's a huge book of business that's really frequency in nature, the smaller cases. And there I think we overuse ADR, because when I came into this industry, and I won't tell you when, it was a long time ago, You couldn't go and get somebody that surrounds us here and then out there to go help you settle the case. You had to go do it yourself. And today on these frequency cases, it seems like the necessary ingredient is getting an ADR set up so you can go talk to the person that you want to go settle a little case for. And so today, the only point I'd like to add is it's like anything else. It's a great idea. It's a very, very useful and proven tool. But we need to go back on those other cases and start doing what we did years ago, and that is go to the opposition's office, go to the claimant's home, and start having those discussions ourselves. We do not need somebody to carry that message. We're perfectly capable ourselves.
Well, I agree with everything you guys just said wholeheartedly. We too have a lot of trucking litigation, and I always try to get those cases to mediation as soon as possible. In many cases, I will do a pre-suit mediation where I'll do a pre-suit deposition of the plaintiff and perhaps their key treating physician, and we agree that if we can't resolve the case, that deposition will be used in the case. But in every single case, every single personal injury case I have gotten to mediation has settled at some point. With respect to your point, we've tried to, I agree with that as well, and we've tried to come up with some creative ways of dealing with that. For example, in New Jersey, we have an arbitrator or a mediator that we use, and we'll bring him in for a week, and we'll set up a whole series of half-day little mini mediations if we can't get the plaintiffs to talk to us in any other way. But you're absolutely right. I wish we could do that, but it's so difficult sometimes because the plaintiffs, too, are like, I want to mediate or I'm not talking to you.